Welcome to the first of a series of sessions by Fox Williams, in which we will share some of our experiences as legal advisors to law firms. I'm Daniel Sutherland, a partner at Fox Williams, and I lead the team here advising professional services businesses. I'm joined today by Ed Livingstone, who's a senior associate in the team. One of the key areas we advise on are partnership disputes, and today we will be sharing 5 of the key lessons that we've learned in dealing with them. So, Ed, to set the scene, when we talk about partner disputes, what are we referring to?
Well, the most common context in which we're asked to advise on partner disputes is where a firm is asking a partner to leave, or there's a dispute around alleged misconduct or underperformance. Specific examples of misconduct might be discrimination, harassment, bullying, or regulatory breaches. Firms will usually be used to dealing with such situations as far as employees are concerned, but it's a more complex landscape with partners. Although these situations are all quite different, they often raise very similar issues of what firms and partners can and can't do. So with that background context in mind, Dan, what is the first lesson for handling a partnership dispute?
So the first lesson, and perhaps the most important, is you must get to grips with the written terms of the partnership. So the starting point is nearly always the partnership or members agreement, and that can be where the finishing point is too for a lot of disputes. But the detail is really key. It's imperative that you get to grips with things like process. For example, do you need a partner vote? You also need to understand timings. How long must the notice period be? And the various other provisions that can be relevant in a dispute, such as duties and so on, and the dispute resolution procedure if there is one. That's of course not the only source of rights, which I think is probably where we come on to lesson 2. You also have to understand the unwritten terms. There are, like employment contracts, implied contractual rights, which will depend on the circumstances, but which may not be obvious, and which any experience you may have with employment contracts may not lead you to realize exist. For example, the issues in partnership law at the moment surround when decisions are taken that essentially are irrational, or the process for taking that decision hasn't complied with principles of natural justice. These kinds of unwritten terms can be traps for the unwary. There are also statutory rights, which are also not written rights. And although there is a common misconception that partners don't enjoy UK employment rights, they do in some key areas such as discrimination, whistleblowing, equal pay, and working time regulation. And even if the partnership agreement says that those rights are excluded, you simply can't. Discrimination in particular is a key consideration. Ed, you got anything you want to add on that?
So that brings us nicely on to lesson 3, which is always be aware of discrimination risk. Discrimination, along with other statutory rights such as whistleblowing, are commonly raised by partners and LLP members. I think in part because the employment tribunal is an attractive venue for an individual who wants to bring a claim. There are no fees for submitting a claim. If unsuccessful, the claimant doesn't have to pay the costs of the winner in almost all circumstances. And I think also the employment tribunal is more hospitable to claimants who are representing themselves, more so than a court or arbitration process, which would be the correct forum for a breach of contract claim. So discrimination law, as many will be aware, applies to a range of different protected characteristics, such as race, sex, disability, and so on. Commonly, we see in partnership agreements fixed retirement ages, which, despite being directly discriminatory on the basis of a partner's age, are potentially lawful if they can be justified. So they are vulnerable to challenge in a discrimination case. I think it's also fair to say that partnerships are often less sophisticated in how they treat partners as far as issues of maternity or part-time working are concerned, much more so than employees. I think another thing to bear in mind for discrimination claims in particular are the high reputational stakes. The allegations made in a claim can be very personal as well. It's not uncommon if a partner is threatening or bringing a discrimination claim to add members of the senior management, such as partnership board, senior partner, etc., as an individual respondent alongside the firm itself in a discrimination claim. So that brings us on to lesson 4, which is to know your objectives. So in discrimination claims and other partnership disputes as well, firms need to be clear about their objectives from the very outset. For example, if the firm's in a dispute with a partner about, say, profit share or a contested compulsory retirement, it's important for the firm to consider whether the relationship is capable of being repaired, or if an exit is the only feasible option. Knowing early on what the firm's desired outcome is will obviously guide the steps to be taken and the strategy to be followed in responding to any claim or threatened dispute. I think another key point related to that is to try and resolve disputes at an early stage. Although partners aren't subject to the same grievance procedures as employees, similar processes can be used to try and resolve partner disputes. So if we're talking about a threatened tribunal claim, the hearing would be public, so there is a publicity and reputation risk there, but there is no reason, even in that case, why the partners and the firm can't engage in a private mediation process by agreement to try and resolve the dispute that way. Although this would need to be arranged quite quickly, given the short period of time in which a partner is required to submit a tribunal claim in particular. So coupled with the issue of knowing your objectives, I think as part of that, it's important to take an early assessment of the merits of the claim, because that will be a key factor in the firm's appetite to settle, as well as how it goes forward in terms of strategy more generally. Although all that said, firms do also need to bear in mind that merits of the claim are not the whole story by any means. So that moves on to the final lesson. Dan, what other pitfalls are there for firms in other types of disputes?
So there's lots of pitfalls, and of course it'll depend on the exact dispute. But there are some common ones that I think firms can plan around, or at least if they're aware, they're forewarned, they are forearmed. And so I think the most important of those potential pitfalls is not understanding the information rights that partners have. So many viewers may already be familiar with the rights under the Data Protection Act for an individual to make a subject access request and get an awful lot of information if it relates to them personally from a business. Partners, they have that right, but they also, unless it's been excluded in the Partnership Members Agreement, will have a much more wide-ranging general right of access to information. And that can include information which may well be quite unhelpful, potentially even legal advice that is relevant to the individual partner. So that needs to be borne in mind, and care needs to be taken about what is written down and sent on email. The other pitfalls are really commercial as well. Client connections are often a key part of a partner's practice, and being in dispute with the partner potentially puts those client connections at risk. And I think understanding things like restricted covenants and the duties that partners owe can be helpful in trying to manage that risk as a dispute rumbles on. And then I think the final things that need to be thought about are really the external issues around the regulatory negative publicity if the claim ever arises. Those are the kinds of things that you can't really control fully, but you can at least plan for them and attempt to deal with them ahead of time. So those are the 5 key lessons we've learned from partner disputes. Clearly, there could be many more depending on the dispute that arises, but we hope that's a helpful summary. And we hope to see you again soon for another bite-sized partnership law session. Thank you.